Good afternoon, everyone. My name is Latika Pai, and I head Microsoft for Startups for the MENA region and South Asian countries. Welcome this afternoon to our webinar, which is very, very critical for founders on force majeure and other legal issues that startups face during these challenging times. And as a part of the Highway to 100 Unicorns, which is what Microsoft initiated in September last year, where we went to several states in the country, six to be specific, where we looked at startups who had the most amount of promise in terms of engaging with them and identifying and nurturing them. We've had a tremendous 6 months in terms of engaging with these states, and as promised, this we continue to do so through our various webinars that we do every Thursday. Today we have with us a special guest. His name is Hansal, and Hansal is a musician, and I thought it would be great to have him perform for us. And we start our webinar with Hansal. Hansal, over to you. If you could please introduce yourself, that would be great.
Hello everybody. Namaskar. Good afternoon. Kem Cho. So this is Hansal Suthar. I am a singer-songwriter, currently based in Delhi because I'm working with Ministry of Rural Development as a consultant. And yeah, my native is Gujarat. I'm a Gujarati. So yep, that's me. I write a couple of originals. I do my covers, and yeah, you can check it out on YouTube sometime, and probably you listen to it. Couple of those here as well.
Great. So, Hansal, what is the genre of music that you like to, work with, like you like to perform with? It'd be great to understand that.
So it is more of a independent music, which is currently, it's like hot topic going on in India after Gully Boy. So I'm more into independent music and soft rock. So yeah, I'm classically trained with Indian classical music. And that's my base. But yeah, I have a keen interest in independent music. So I write my own songs and do something original of mine, which is not like a mainstream thing.
And you have a very interesting name as, when you perform. So if you could tell the audience, how you came up with that name, that would be great.
Yeah, so my artist name is like Barbad Baba. So people normally call me Baba. And that's basically because of my look and my interest, like my special love for mountains. Mountains and traveling inspires me to write and sing. So yeah.
Great. And as far as your work is concerned, do you play, sometimes when you travel with work, you're doing some very interesting work with the Ministry of Rural Development. So
yeah. Yes, so I work for Ministry of Rural Development and I'm handling this program called Mahatma Gandhi Narega. Which is basically rural employment program, and yes, I do travel for music as well, but I can manage both, so that's not a problem so far.
I'm always extremely envious of any musician, right? I think if there's one skill that I would have loved to have, my friends, honestly beg me not to sing. So. So it's always a pleasure to host a musician, and I must thank Sonia Choksi of Match My Talent, which is doing a phenomenal job in terms of identifying and promoting musicians in the country. I think she's got tens of thousands of musicians out there. So Sonia, thank you for introducing Hansal to us. Hansal, over to you to perform, and thank you again for being a part of this webinar.
Thank you so much, sir. Thank you so much, Latika. So yes, I'm performing one of the originals of my latest release album with the name of Dastan, and the song particularly is about a Dastan which is unheard and which is out there. Which we are actually experiencing the natural events happening around in this lockdown, and all these natural elements are trying to tell us some story that we must listen to. So this song is called Dastan. ये वो वक्त की बात है जो वक्त हर वक्त था, जो वक्त हर वक्त है, जो है किसी ने ना सुनी ये दास्तान कुछ अनसुनी, वो वक्त अब भी जी रहा, क्या शख्स वही तू नहीं। ये हवाओं का सरसराना फड़फड़ाना जुगनुओं का यूं जगमगाना बारिश का यूं बेहिसाब बरसना दास्तां है कोई कह रहा दिल से दूर सुन ले जरा दास्तां है कोई कह रहा दिल से दूर सुन ले जरा राती चंचल तितलियां कह रही तो आ गया है कहाँ टहनियों में खिल रही गिलहरियां ले रही है रात की अंगड़ाइयां अनकहीं ये बातें अनसुनी कहानियां अनकहीं ये बातें अनसुनी कहानियां ख्वाहिशों का ये दास्तां दास्तां है कोई कह रहा दिल से दूर सुन ले जरा दास्तां है कोई कह रहा दिल से दूर सुन ले जरा Thank you so much, everybody. And thank you, Latika, for giving me this chance. You can find out more songs on YouTube by searching for my name, Hansal Satha.
Thank you so much, Hansal. And I know you're going to end this webinar singing another song, performing another song at the end.
Yes, for sure,
so
for sure.
Definitely look forward to it. And that was absolutely wonderful. Thank you again.
Thank you so much.
Great. So now we'll move on to our webinar focused on all the legal issues that we are anxious about. We have with us this afternoon Ramanand Mundkur. Hi, Ramanand.
Hi, Latika.
How are you? So Ramanand is the managing partner at MLP Law, one of the leading corporate law firms in the country, and they advise clients both here in India and globally. Ramanand, thank you so much for being here with us today, preparing the deck and letting startups, most of our audience today come from the startup community. And, having been a founder myself, I've always thought I was half a lawyer because I would kind of go online and, look and take documents and believe that I know what's going on. But the reality is that at these times when we are, when clients, employees, etc., are trying to get out of their, their agreements with the founder, it's very important to understand what the fine line, the fine details that are there in legal contracts. So over to you, and thank you again for being here. The format is that we'll have you go through your presentation and discussion points, post which we will, take some questions from the audience, and I will make sure that we'll try and have as many questions that the audience has for have you respond to them. One question that has come in from the audience is this webinar meant only for startups in India, on how much of this will be applicable for startups coming out from other regions outside of India?
Sure. So thanks, Latika. Let me, before I upload the slide, let me address that question. The focus of my presentation today is really on what Indian law says. However, some of these principles and certainly the practical examples would be relevant in a global context as well. The examples that I'll be speaking to would apply to Indian startups that have cross-border transactions, as well as to global startups that are doing business with India. So to that extent, yes, there is a global relevance, but the focus is primarily Indian law, and the relevance is primarily for startups in India.
Okay, great.
Business with India.
Okay, great. Thanks. Thank you so much. And over to you, and look forward to hearing more on what you have to say.
Thanks, and thank you also for that musical introduction. Given the lockdown and how tied up we all are, it's always good to have something light, nice, and wonderful like Hansal's music to bookend a subject like force majeure.
Ramanand, I know you're quite the musician, right? So at the end, I'd be absolutely happy for you to pick up a guitar and sing for us too.
The only thing I've been accused of is making a racket. So
no. I beg to differ on that, but anyways, we'll for another day then.
Thanks, Latika. Let's
sure.
Get underway. Right. I'm not sure if you can see the slides just yet. But what I'd like to cover today are basically three areas. I know a lot of businesses in India and startups in particular are facing situations where either their counterparties are threatening to sever contracts or to stop performing on contracts. And at the same time, the startups themselves are looking at contracts that they've signed and wondering what these events like the lockdown and the pandemic mean or imply in terms of their obligations to continue to perform these contracts. So the first thing I'd like to look at are what are the general principles of law, of Indian law, that apply in a situation like this, in a situation of force majeure. Having looked at the general principles, it's also important to be clear that those general principles don't apply in every single case. There are special situations where either there's a statute or a government notification that controls, and in those cases, the statute becomes definitive, and the statute is where one has to turn to figure out what the implications of these events are in terms of the contracts that are covered by that statute or that are covered by that government notification. And we'll look at examples of those special situations, certainly the most common examples, but also ways of thinking about where those special situations might apply. And the last area, which is really the area that I'd like to try and spend as much time as possible on, is what happens in practice. How should we be thinking about this in practice? It's good to know what the law says, but what does that mean practically? What should businesses do? What should companies do? What should startups do? So without further ado, I'll just jump right into the general principles. The way the law in India is structured is because we have an Indian Contract Act. The common law principles that are applied in, say, under English law are not directly applicable. They might have a persuasive value, but they're not directly applicable. And what the Indian courts have consistently said is that when looking at events like force majeure, we have to be guided by the provisions of the Indian Contract Act. And in this regard, there are two ways in which the Contract Act could apply. The first is if there is an express or implied force majeure clause that applies and that is contained in the contract that we are dealing with. In that case, one set of provisions apply. And if there is no force majeure clause, or the force majeure clause that that's there in the contract is not applicable, and we'll talk about examples where it might not be applicable, then there's a second way of dealing with the contract. So going back to the first way of dealing with the contract, which is where there is an express or implied force majeure clause that applies in the facts of the case, then what the courts do is that they say that what we have before us is something called a contingent contract. Now, contingent contracts are dealt with under a specific provision under the Indian Contract Act, which is Section 32 of the Indian Contract Act. And the way a contingent contract works is that the parties say that if an event occurs, then a set of contingent obligations follow, or a set of contingent rights follow. So it's contingent on the event occurring or not occurring. And they therefore say that a force majeure clause is like a contingent contract. So the parties have already said, if a force majeure event occurs, then certain conditions would apply, certain rights or obligations would follow. And what the courts do in that case is that they look at the clause of the contract and then they would apply the clause of the contract. So it's very hard to come up with a general rule in these situations because each contract will have different language. It will cover certain situations. It might exclude other situations. And the consequences could also be different. So in our experience, for example, the most common consequences we see are situations where if a force majeure event occurs, the performance can be suspended for the period of the force majeure event. Sometimes the contract says it can only be suspended by one party and not by the other. The other situation that we see is if a force majeure event continues for a period of time, either party or one party in particular has the right to terminate the contract. And so the contract itself deals with the consequences that apply. Now, in these situations, it's important to read the force majeure clause very carefully. In infrastructure projects, typically in project financing agreements, you have force majeure clauses that run to 2 and 3 pages, just that single clause. And a large part of that clause deals with situations where an event will not amount to force majeure. And what the courts are basically doing in these situations is saying that the parties have already anticipated such a situation may or may not occur. And they've already agreed as to what the consequences will or will not be. So let's give effect to their agreement. So that's the first set of situations that are covered by the Contract Act.
Ramanand, just to simplify it, for the audience, in today's COVID-19 situation, what does force majeure mean? And how are people kind of pulling it into contracts?
Right. So let me answer that briefly now. I had planned on taking that up in the context of looking at issues, from a practical point of view, specific to the COVID-19 and the lockdown. Now, typically in a force majeure clause, force majeure events are classified as involving acts of God, riots, changes in law, epidemics, etc. I think given what we are seeing before us, it would be very difficult to find a situation where a court or a tribunal will say what we're seeing is not an event of force majeure. And I say this mindful of 2 broad principles. The first broad principle is typically when a force majeure clause is drafted, the language used is illustrative. It is not intended to be exhaustive. It talks about events like epidemics or riots or floods and hurricanes, acts of God, other acts of God, riots, acts of war, changes in law, etc. It's intended to be illustrative. So even if the word pandemic is not used, even if the word lockdown is not used, a lockdown would be a change of law. And a pandemic of this nature would, in my view, in almost every case, amount to an act of God. So it would be, if you have a force majeure clause, it would be extremely rare. I don't want to say it would be impossible, but I like to say it's extremely rare that the force majeure clause would be excluded in this situation. The one area I'm a little nervous about commenting on are insurance contracts, because typically in insurance contracts, they're very, very astute in terms of the risks that the insurance company wants to take on. So one has to look at the contracts very, very carefully. And in most cases, what we're witnessing today would be covered by the definition of force majeure. Now, once you're covered by the definition of force majeure, the consequences that are set out in the contract would then follow, assuming you do have a force majeure clause. But let's come to the second area, which is assume you don't have a force majeure clause, or for some reason, the clause that you have clearly does not cover a situation like this. In that situation, a different set of rules apply under Indian contract law. And this different set of rules is referred to as the Doctrine of Frustration. It basically talks about a situation where you've agreed to do something, and after you've signed your contract, an event occurs over which you have no control and which you cannot prevent. An event occurs that you did not anticipate that makes it virtually impossible to perform your obligations. Now, there is a separate set of rules and a separate set of requirements that have to be met in order to be able to invoke the doctrine of frustration. So, for example, merely because things have become harder to perform, that does not allow you to invoke the doctrine of frustration. What the Indian Contracts Act says in these cases is, if you've agreed to do something, if you've signed a contract to do something that becomes impossible after the contract has formed, then that contract is void. And when you say that the contract is void, that's a technical legal term. It means that the contract, the agreement that is part of the contract, is no longer enforceable under law. Now, in order to meet those requirements, there are two tests that the courts in India apply. The first is with regard to the act becoming impossible or unlawful, which is what the Contract Act refers to. Indian courts have said impossibility is not limited to literal impossibility, right? If it is practically impossible, having regard to the object and the purpose of the contract, then that impossibility requirement is met. The second and related aspect is that the event should dislodge the very foundation of the contract. So let me give you an example. Let's say you've got a leave and license agreement, and I'm deliberately staying away from lease agreements because there are specific provisions under the Transfer of Property Act dealing with leases that are subject to force majeure. But let's assume you've got what's called a leave and license agreement. Typically, most office premises are covered by a leave and license agreement in the Indian context. And let's say you're not one of the exempt industries that were exempt from the lockdown. If your leave and license agreement didn't have a force majeure clause, and the lockdown has prevented you from using your office, accessing your office, it would be possible to contend in that situation that the very foundation of the agreement has been dislodged. The reason you've entered into the agreement is to be able to use the office, and that's why you pay that rent or license fee. if the force majeure event, which is the lockdown and the pandemic, prevents you from now using the office, it may be possible to argue in that situation that the force majeure clause has dislodged you. But in dealing with clients, we've come across situations where they have leave and license agreements and they have businesses that are actually using the offices during the lockdown because they were part of the exempt industries. Now, in that situation where you're actually using the office, you can't turn around and say, I may have been using the office, but I won't pay you because anyway, the lockdown is a force majeure event. And so sorry, Latika, you had a question there.
Yeah. So just to make sure that the audience understands, what you're saying, Ramanand, is that if you had an office premise that you were unable to use because of the lockdown, then you have a case of not paying rent. Now, if you had
you may have a case, yes.
You may have a case. And if you had an office that you were using, because you were one of the exempt industries, you can't go back to your landlord and say, hey, I don't want to pay when you've actually used it. So it's
Absolutely.
only the former situation, which makes sense, which says that I was paying you X amount a month, but I've not been able to use this as a result of this pandemic that's coming out, and as a result, and I want to be able to be given some concession in terms of my rent for the time I didn't use it.
Well, so let's talk about that, okay? Because that's the part I want to focus on at the end. So this is just what the law says, okay? And in terms of how we then go and apply the law, there are a few other considerations that I think it's important for startups particularly to keep in mind. This is just what the law says, right? And we'll talk about the practical application of the law in a bit. Let's just quickly go over the special cases where these general principles that are contained in the Indian Contract Act are modified because of provisions in a statute, because of government contracts, etc. And I think the first case that we really should deal with as a special case is employment. A lot of businesses are facing challenges with sustaining workforces, are talking about either pay cuts or even retrenchment and layoffs. Now, the labor laws in this country, and until the wage code is enforced and becomes law, the labor laws in this country are extremely diverse. They treat workers, quote unquote, differently from employees who do not qualify as workers. They apply to certain establishments. They don't apply to other establishments. In certain cases, states have made exemptions on the application of labor laws to certain types of establishments. So, for example, in Karnataka, which is our home state, there is a notification which exempts IT industries from application of employee standing orders. So there are variations not just across the labor laws, but across states in the application of those labor laws. In addition, there are, in the COVID and lockdown situation, specific notifications that have been issued both by the central government and by state governments with regard to treatment of employees, with regard to treatment of workers in particular. There was an advisory that was issued by the Ministry of Labor to various departments, to various state governments. The advisory asked these departments, state governments, industry associations to avoid retrenchment, to try and retain employees. But remember, it was only an advisory. Far more significantly, on the 29th of March, the Home Ministry issued a notification under the Disaster Management Act. Now, the Disaster Management Act has totally different implications. The failure to comply with the obligations under the Disaster Management Act can draw penalties as well as imprisonment. It's pretty serious if it's not just an advisory, it's the law. And the notification of March 29th issued under the Disaster Management Act, which was in the context of particularly migrant workers, had a requirement that state governments issue directions requiring that workers in establishments not be retrenched or not be subject to pay cuts during this period of the lockdown.
So, Ramanand, I want to again kind of hone in on for startups, right? What does this mean? That startups are unable to reduce their headcount, retrench, or again, is the March 29th Act applicable to startups, or is it only for more of the like you said, migrant workers?
Excellent question. You preempted my very next point. What this basically means is that not just startups, but every organization will need to take a step back to figure out which labor laws apply to the type of employees we have. So there might be startups that are engaged in manufacturing who will have a population of workmen who are covered by these labor laws, by the advisory of March 29th, as well as by other labor laws that protect workmen. So even without the advisory of March 29th, for example, if you have an individual who is a worker protected under the Industrial Disputes Act, force majeure event or no force majeure event, there are specific procedures that have to be followed for any retrenchment or layoff. And so each organization will need to take a step back and figure out which labor laws apply to that organization, given the states that the organization is present in, given the states in which the employees of the organization and the workers of the organization are present, and then make an assessment as to whether the special laws that apply to employees, the labor laws that apply, are applicable to its employees or not. You might have a startup that's in, say, financial services, who might not have any workers covered under the law, either because their salary thresholds are over what the laws prescribe as the salary thresholds for workers. And there are, unfortunately, even today, there are different salary thresholds that are prescribed for workers under different laws. If I'm not mistaken, the Payment of Wages Act prescribes a threshold of 24,000 rupees a month, while the Industrial Disputes Act continues to prescribe a threshold of 10,000 rupees a month. So there are these differences, and it requires a little more analysis and a lot more care when dealing with employment. It's not like one can sort of take a blanket view and say, I am covered or I am not covered. You've got to get more granular in the analysis specific to your organization.
So for startups who are always, anxious about spending money on lawyers, right? What would your advice be? Because this is, you're really caught in a bind right now to say that, if there are multiple labor laws that are potentially applicable, right? How does a startup even begin to think about it?
And just to add a little more complexity to the issue of whether software coders are or are not workers, if they're not engaged in a supervisory or administrative or managerial position, is still before the courts. It's in a case that's been pending before the Supreme Court for some years now. And it's still not clear whether software workers who are not engaged in a supervisory, administrative, or managerial role are workmen covered by these labor laws or are not workmen covered by these labor laws. There was a case that went up before the Bombay High Court. A single judge took the view that they are covered. That was appealed to the Supreme Court, and the appeal is currently still pending before the Supreme Court.
So you're
unfortunately, this is one area.
You're referring, for example, to a programmer.
To a programmer, exactly.
Okay.
This is one area, because the Disaster Management Act notification applies, because there are specific labor laws that apply. This is one area where you want to get proper legal advice, preferably from an employment and labor law expert. I'm not an employment and labor law expert. You want to get proper legal advice from an employment and labor law expert in the state you're in before you take any action that affects either the employment terms or the employment relationship with individuals in your organization.
So
now, if you've got, let's say, high cost employees, okay, let's take the low hanging fruit here. Say you've got high cost managerial employees. Okay. In that situation, it is most likely that they will not be protected by labor laws, and you can start looking at renegotiating the contracts with them, having discussions with them, and resetting the bar with them. But when it comes to workers, when it comes to people who are not in managerial roles and who are not in administrative and supervisory roles, you want to be far more careful in the way in which you deal with them. And for the most part, you might find that the lower the pay, the more careful you want to be. You want to protect pay you certainly want to protect pay for employees who are receiving lower sums of money, and really focus on the managerial and supervisory employees to the extent you're feeling severe cost pressures at this time.
One last question, and I'll let you move to the next slide, Ramanand, is that the most startups, I would assume, would have an employment contract with their employees, which would also have their notice period, right? That, which could be anywhere from 30, 60, 90 days. That is something they can also invoke without force majeure, right? It could be for just business, for business reasons. Nothing
Assuming that the employee does not get protected by a labor law, yes, the answer is they could invoke the contractual provisions in that case. But if the employee is protected by labor law, because that employee is a worker, then the contract alone will not apply. You'd have to look at what the provisions of the labor law say with regard to either retrenchment or layoffs or even salary revisions.
Okay, great. So I think the message to the audience is, please look at your employee roster, identify which ones are in the supervisory managerial category, identify which ones who you could potentially be in this gray zone of being workers in terms of, from a software programmers who are part of it. Look at the ones who are doing, BPO operations related work, and kind of create those broad categories, and then speak to an expert on whether the March 29th Act is applicable to the people on your teams.
Absolutely.
Great.
I just want to quickly go over the other three special situations that you can see there on that slide.
Sure.
Because a lot of startups particularly engage contract workers. These contract workers might be doing facilities management, they might be doing other jobs, they come on board through a contractor organization. Now, typically, even if these contract workers qualify as workmen, one might argue that the real responsibility to deal with the employment relationship, to protect those contract workers, is on the contractor organization. But the law provides that if the contractor organization doesn't, for example, pay the contract worker the amounts due under that contract, then the principal employer would become liable to make that payment. Sure, the principal employer can subsequently go after the contract worker, but it is in your interest as an organization to make sure that your contract workers are also being treated correctly under the law. On financial services.
Hang on 1 minute, Ramanand. This is also very important. So if you're saying that you have a security guard guarding your office or your building, or housekeeping staff that are coming in, that you have a contract with, say, ABC Contracting Company, the onus continues to be on you, or is it the onus on ABC Company?
The primary obligation is on ABC Company. However, if ABC Company doesn't pay that security guard or that housekeeping staff, then the security guard or housekeeping staff can bring a claim against you. Because in that case, your status is as principal employer.
Okay.
Okay, you might subsequently then, after paying off the security guard, have a claim against ABC, but you want to avoid having to go before the labor commissioner to make sure that the contract workers are properly paid, and to have to deal with the cost of that additional process and that additional procedure.
Okay. Okay.
With regard to financial services contracts, I know that there are really 2 points that I'd like to flag out here. One is there were specific announcements about the moratorium on loans that are being paid. There was also a notification that extended the period for payment of insurance premiums, whether it's for health insurance or car insurance during this period. But with regard to the moratorium on loans, I think it's important to re-emphasize, and I think this has been in the public domain, but particularly for startups that are worried about both cash flow as well as the impact on EBITDA, the impact on the bottom line going forward, that a moratorium is not a waiver. The interest continues to accrue for the period of the moratorium, and depending on the period of the outstanding debt that remains, the amount of interest can be pretty substantial. So it can have a long-term impact on your total cost of funds, even if you were to sign up for the moratorium. It's therefore important to do the arithmetic before electing for these for the moratorium. In some cases, you may have very little choice because cash flow is so badly strapped that you really need to protect cash flow, even if it comes at the cost of impacting the bottom line later on. The other point I want to touch upon in financial services is with regard to performance guarantees and bank guarantees. And I'd like to talk about 2 different situations that have arisen in the recent past to talk about how the practicalities play out. But the general principle to remember is that it's almost impossible to get a bank guarantee encashment stopped. There are very, very, very specific situations and very, very limited situations under which you can get the encashment of a bank guarantee stopped. Ordinarily, the way the Supreme Court has dealt with the case, and the Delhi High Court 2 days ago has slightly, well, for want of a better word, interpreted the way the Supreme Court dealt with the case. There were only 2 grounds on which you could get enforcement of a bank guarantee stopped. The first was that there was fraud involved in the bank guarantee, in obtaining the bank guarantee, etc. That's not applicable in this COVID-19 lockdown situation. The second situation that the court came up with was to say that it would result in an irretrievable injustice. And the phrase that they used was that to stay the encashment of the bank guarantee would either be required because of an irretrievable injustice or special equities. I want to leave that phrase hanging for a little while because I really want to talk about it on my next slide in terms of what does it mean from a practical point of view? What are these special equities? What is this irretrievable injustice?
I was going to ask you, Ramanand, please say it in simple English. I don't understand
exactly
what you just.
Absolutely. So this is where it gets a little legalistic. So I want to focus on the practical implications of this. And before moving into the practical implications, I also want to say that this list is not exhaustive. There are other sectors that are regulated. Education is a key example. If you're running schools, if you're running colleges, the government has come out with a bunch of notifications, both at the center and the state, that has an impact on your operations. And these notifications would be the primary source of what the implications of the pandemic and lockdown are on your contracts before we move to the general principles of force majeure. So setting that legal context as the background, let's really talk about what happens when the rubber meets the road. The first thing I'm going to say is going to be a little, for want of a better word, contradictory to everything I've just said. The first thing I'm going to say is it's not just the law. You've got to look at the facts of each case to figure out what's going to happen in practice. You can have the law completely on your side. You can say that I've met every single requirement that applied in these various judgments of the Supreme Court and these various statutes, etc. If you don't have the facts, and by the facts I mean the fairness of the situation on your side, if there is some sort of gaming of the situation, the courts in this country are, particularly in commercial matters, are extremely astute, and they'll pick up on that. And let me give you two examples from the recent past dealing with bank guarantees and letters of credit to illustrate that. About 2 weeks ago, a company went to the Bombay High Court. They had received a consignment of steel from Korea, which Hyundai had shipped across to them despite the pandemic, etc. And this company went to the Bombay High Court and said, force majeure applies because of the pandemic, because of the lockdown. So please give me a stay on encashment of the letter of credit that was open to pay for this consignment of steel. And they cited these various Supreme Court cases before the judge in the Bombay High Court, and the judge refused to grant them the stay. The judge said those cases do not apply. The facts are out here. The shipment of steel is actually one of the exempted sectors. The ports were functioning. You could have removed the steel. So the fact that you can't then sell the steel to someone else does not excuse you from making the payment to your original supplier who met the obligation of supplying the steel to you. On the other hand, just 3 days ago, there was a drilling contract going on in Rajasthan between two really big companies, Halliburton and Vedanta. So Halliburton had signed this a bunch of contracts to drill 3 fields in Rajasthan. They were supposed to have finished that job sometime in 2019. There were slight delays, etc. They've been talking about the delays, and then these events occurred. The restriction on travel, the pandemic, and then eventually the lockdown. Vedanta threatened to encash 8 bank guarantees, and they went to the Delhi High Court. And here the Delhi High Court said, look, there had been discussion between the parties. They were about 2% and 5% away from completing their contracts. I will grant the stay in this case on encashment of the bank guarantees, because if I don't grant the stay and they encash the bank guarantees, it would result in irretrievable injustice. Irretrievable injustice to Halliburton in that situation, and the equities, which really talks about the fairness of the facts. But in doing so, what the court said is, I will only grant a stay for 1 week post-lockdown. So you've got to make sure that you finish all the work within 1 week as soon as the lockdown is lifted. The point that I'm trying to make through the illustration of these cases is that the courts will look at the facts of your case. And the judges will be able to distinguish between whether you're gaming the situation and trying to take advantage of it, or whether this is a genuine situation where one needs to look at whether the contract has been frustrated or whether performance has been rendered impossible and the fundamentals of the bargain are gone.
So, Ramanand, my question to you is that, you're talking a lot about the courts and going to court. Knowing our Indian judiciary system where things go on for years and years, you're not going to get any quick answer coming your way again as a startup.
Absolutely.
So I think
once again, Latika, you've preempted my next point.
Yeah. Because I'm just putting my startup founder hat, saying this is great, Halliburton,
Absolutely. Absolutely.
They have the muscle power of taking, getting their lawyers. But I think from a very practical perspective to say, okay, what are the obligations that a startup founder / employer has towards his employee, towards the contract that he has, and how does he or she move forward?
Absolutely. So let's take a step back. Look, if the Halliburtons and Vedantas of this world are already in court, the courts are only going to get more crowded with the larger companies that are fighting these high value contracts that run into millions of dollars, hundreds of millions of dollars. And the startups are going to get stuck in court for the longest period of time. And while in some cases you will have no choice but to go to court, as a startup founder, I think your first question is, what are my other alternatives? How should we be thinking about a situation like this? And I think it's important when you're looking at your other alternatives to have two frames of reference in assessing those other alternatives. You need to look at the short-term implications and you need to look at the long-term implications. You need to look at the short-term implications primarily from the context of survival. Primarily from the context of making sure that you do make it to the long term. And you need to look at the context of the long-term implications, knowing that if you do make it through this terrible shock that the world is going through and that India is going through, you will still need business relationships. You will still continue to partner with your business partners, and you will still need the goodwill of how you as a business hope to function, hope to grow, hope to thrive in the long term. And in that context, I'd like to focus on these three aspects. So both with the short-term framework and the long-term framework. I don't think there's a trade-off possible out here. I don't think it's a binary choice between short-term and long-term. One has to keep both frameworks in mind for a viable solution. So the first is, wherever possible, speak to the other side. Because remember, both sides of the contract are probably hurting in this situation. Almost everyone is a victim. There are very few businesses that have actually benefited from the pandemic or the lockdown. And to that extent, recognize that it would be useful to start that conversation again, to look at either negotiating or renegotiating the contract in the context of the ongoing lockdown. The second thing that I'd like to say is it's really important, whichever side of the contract you're on, whether you're seeking to renegotiate performance of your obligations, or whether you're seeking to renegotiate the terms on which you receive someone else's obligations. It's really important to be reasonable and fair, because that will come back one way or the other. It will come back in the context of the relationships you build. And if you're not reasonable and fair, it might come back in a situation where you don't reach a negotiated settlement and you find yourself in court, where the costs will go up and where the the ability to continue to deal with these fights in court and these processes will already be slanted against you because your unfairness will be part of the record. So it's important in these discussions to be reasonable and to be fair. And honestly, I think all businesses understand that we're working towards profit margins, we're working to save costs, and they continue to have discussions in normal times on that basis. I see no reason why those parameters get altered because we're in a situation like this. And the final thing is, I know we have challenges in this situation, but the really successful businesses are the ones that can turn challenges into opportunities. So look for the opportunities to sustain relationships, look for the opportunities for potentially new business or new ways of doing business, so that you give yourself a better chance, not just to survive, but to thrive. So great. I'm sure there are a bunch of questions. I'd be happy to take them on as best I can right now.
Okay, great. So let's go to the first question, which is, I want to have Ramanand's view on the co-working industry, specifically for clients looking to terminate their rentals using the FM clause and landlords not agreeing to the waiver.
I have to say, before I answer that question, that's an issue that we're facing ourselves. It depends on the contract you have. And each co-working landlord has a slightly different contract. Some of them have force majeure clauses. Some of them don't have force majeure clauses. Some of them have extremely one-sided clauses that only talk about situations in which their ability to provide the facility is impacted. And there are situations like the one we talked about, which is if you belong to one of those exempt sectors that were allowed to actually use the office, it would be not just legally untenable, but unreasonable to then say, I'll use the office, but because there's a pandemic or a lockdown, I won't pay the rent. If, on the other hand, you are one of those situations in a situation where the lockdown prevents you from using the office, it would be unreasonable and untenable for the landlord to say, I don't care, you still have to pay me. Or we don't have a termination option for you, or you've got, go through the standard termination clause. Because if you can, in that situation, establish that the contract is frustrated, then the contract becomes void. It is no longer legally enforceable. So my suggestion out here is you need to go back to the contract and always leave the door open to negotiate and renegotiate.
Now, what about the fact that we're only talking about the lockdown period here, Ramanand? What about, the fact is that if we now that employers are comfortable with their team members working from home, right? And they've realized that they can get the productivity, they don't need office space. So, we've talked at length about not paying rent during the lockdown period, right? What about if you want to just now walk away from your contract? Is that something that's even possible, or you have the?
I wouldn't advise it. I wouldn't advise it for the simple reason that you've signed a contract. You can't, and if the contract is void, that's one thing. But if the contract is not void and the contract continues to hold effect, then you've got to stick by the contract terms. So if the contract terms have a termination clause that allows you to terminate with, say, a year's notice or 3 months' notice, then that's what you've got to do. The fact that it's now cheaper to work from home and we can all use Teams or Skype or Zoom to achieve the same level of productivity is not a ground to just walk away from the contract.
Thanks for clarifying that, because I do know I was speaking to some of the founders who are kind of tempted to and wondering whether they can club this all in the force majeure clause. So I'm glad you made it really clear that this is, if anything, it's only during the lockdown period and not not post-lockdown because it suits your business purpose. You're still obligated towards that.
Here, let me just clarify one point. If your contract is now void, it doesn't come back to life post-business. It is void. That's the end of the contract. So you'll have to enter into a new contract for the post-business period. But if your contract is not void, if your contract continues during the period of the lockdown, then you've got to continue to apply that contract.
Okay, great. The next question, while I'm just looking through the questions for the audience, please go ahead and tweet. We have a really good swag bag that we'll send to whoever tweets the most. You've got the hashtag in front of you on the screen. The next question is that would operations staff located in Bangalore be covered under this law? I think he's referring to the contract law.
Sorry, I have to confess, I don't understand the question. Would operations staff?
Yeah. So you were referring to, I think he's referring to contract workers, right?
Right.
For the March 29th Act that you mentioned. Would
Yes.
the operations staff?
If they are workers, then yes, they would. If they fall within the definition of workmen under labor laws, then yes, they would be covered by the March 29th circular. And while the contractor would have the primary obligation, the principal employer, which would be in this case your startup, would have a backup obligation to make sure that they are paid.
Okay, good. The next question is, I would like to understand Ramanand's view in cases where there is no force majeure clause in the contract. How can I protect myself?
So as I mentioned, if there is no force majeure clause in the contract, then as we said, there is the law, and you can use that as a basis. But what you really should be doing is looking at negotiating or renegotiating the contract. If, however, you find yourself having to go to court, then the law on the point is that when there is no force majeure clause, the contract would only become void if performance is impossible or if it is impracticable, giving reference to the very object and purpose of the contract. So the fundamental of the bargain has to be displaced. It is not possible to say a force majeure clause applies only because the contract has become harder to perform. So for example, you can't say, I'm running out of cash, so making this payment is a little more difficult. That's why I'm invoking force majeure. The bargain itself has to be displaced. The very foundations of the agreement have to be displaced. And the performance has to become impossible or impractical with reference to that fundamental bargain.
Okay, great. The next question is that if you've taken up a space and taken your own office equipment in there, like tables, chairs, etc., does that mean you are using the facility? This is more from a rental perspective. How does that, just because your stuff was there on premise?
That is a tricky one, and in most cases, unless you've told them to remove it until you are able to come and remove it yourself. Let's say that because of the lockdown you are not able to remove it. One set of rules would apply, but however, if you are able to remove it from the premises and you leave it there, then yes, you would be using the premises.
Okay, so the point is that if you've left your stuff and you've not told them to take it, technically you're still using the facilities, and you owe the landlord.
Yeah, so you need to basically say, listen, I'll come and get my stuff. I can't do it right now because of the lockdown, but as soon as the lockdown's lifted, I will take it out. If you want to remove it and put it somewhere safe, please go ahead. I don't have an objection to that. But if you say, please make sure that it stays untouched and unmoved, you're effectively using the premises.
Okay, so that's good clarification. Next question is, we are a technology company and we charge on per order basis to our customers, and there is some minimum guarantee amount as well in the contract. My customers are asking me to waive the minimum guarantee as there is no transaction in the lockdown period. However, I continue to carry the costs 100% like cloud, technical support, tech team salary, etc. So basically you have, on the other side, here you're trying to do good by your employees and your landlord and your cloud provider. But on the other side, your final customer is trying to renege out of the contract. So what safeguards does this founder have?
Well, this is a question we're getting from a lot of clients. We're hearing this very, very frequently. The most recent example I can think of was a client that's built this IT park. They've got loans that they need to pay back to the banks and financial institutions, which are fairly sizable. And there are occupants who want to use the facility but renege on the contract, or who want to defer payment of rent for the period of the pandemic, not just the lockdown. So there's a lot of jostling for position out here. I think the best thing to do is take a step back and see what is the value of your business proposition, of your product, to these customers who have a minimum guarantee situation, and to pick up the phone with them and say, listen, this is the value that we continue to deliver during this period of lockdown. In addition to delivering value to you, we continue to incur costs because we are delivering that value to you. So if you now benefit from the value that we're providing, if you benefit from what we're offering you, then it makes sense to at least make sure that we are able to meet our costs so that we can continue to provide that value. Now, does that mean you have to renegotiate your minimum guarantee? Maybe it does. But does that mean that you sustain and you maintain a business relationship going through the period of the lockdown and the pandemic? That's an assessment you'll have to take. Is the business relationship worth it? If you find that you're incurring costs, you're not recovering those costs, and the customer is actually bleeding you and is not willing to renegotiate so that it's a win-win for both, then you've got to take some hard decisions on whether you want to lose that customer, whether you want to look at alternative business approaches, and figure out whether it makes sense to sustain that contract at all. So I think
I agree with you, Ramanand. I think my advice to the founder who just said is to look at what has been the lifetime value of the contract with this particular customer. Don't jump because of this 1 month. If this has been a client that's been a good client to you over the past year, past several months, then have a discussion, make a call and explain it to the client, just like how Ramanand mentioned to you. However, if this client has typically been known to haggle with you and push you into a corner, then you may want to figure out whether you really want to continue to do business with them. Because if they don't want to pay a minimum guarantee right now, what are the other terms they're going to come and sick you with in the next several months? Remember, lockdown is only one part of it, but none of us have any idea as to how long this is going to take. So at this point, you really want to work with a few customers that you know are going to pay you and be fair to you, more importantly. So that would be my recommendation. I've been a founder who's made the mistakes in terms of watching my startup bleed and then being unable to kind of recover from it. And this is not during a lockdown period, just in terms of running my own startup. So evaluate each one of your clients / customers today and see which ones have been good to you and to whom you want to give a break, and then make that decision about whether you want to get, stick to the contractual terms and obligations that they have with you.
And just to sort of emphasize the key takeaway here, which is, it's important to know the law. It's important to know what your rights are. But when you make decisions like this, I think the primary issue needs to be, how is that decision going to impact your business? And what the law says and the impact on your business might not be directly correlated. The issue on finances, on cash flows, on business relationships are seldom going to be correlated to what your rights under the law are. And so you need to make an evaluation of those issues on finances, etc., and business relationships while knowing what your rights are under the law.
Okay. Next question is about employment, saying that is it common to have the force majeure clause in employment / appointment letters? And if it's not there right now, can we put it in? What is your recommendation?
I've seen both. Although I have to say, more often than not, the force majeure clause is not there in employment contracts. If you want to change any employment terms, you need the consent of the other party. You cannot unilaterally turn around and say, oh, we're just putting a new clause in. And remember, it goes back to that earlier point of being fair and reasonable. Let's assume that the employment contract you're dealing with is not a worker. Let's assume that it's covered by the general principles. This is a managerial position, maybe even an expensive managerial position. But the issue of being fair and reasonable, the issue about looking at both the short-term and the long-term impact still applies in these situations. And trying to unilaterally impose terms is not going to benefit the business, and it's certainly not going to benefit the relationship.
Okay, great. The next question, I'm just kind of scrolling through, which is saying that we have an AMC in place, paid quarterly for a service that can't be rendered during the lockdown. Will the client be able to stop payments? We have staff hired for that particular client, whom we continue to pay as well as continue bearing other costs. So I think this is similar to the one that was asked earlier. And yes. I think my advice would be to look at the long-term value of the contract before you jump in terms of pushing them. Again, absolutely everything and more will be achieved by being polite and trying to engage with either your landlord or your client. I think that's really rule number one, in terms of the minute you talk about a contract, you talk about a lawyer, I think people are going to get aggressive. So my recommendation is understand what you do have in terms of the law protecting you, but at the same time be very, very cautious on how you are kind of engaging on these conversations with everyone.
And also to remember that everyone is hurting. Everyone is a victim of this situation. It's affecting every single business, and every single business has costs. Every single business has employees that they're trying to whose expectations and needs they're trying to meet and manage. And so it's great to know the law, and it's really important that you do, because you don't want to be taking positions that are inconsistent with the law. At the same time, you've got to recognize that in order to actually come out of this effectively with clients and or landlords or with customers, it's really important that how you behave with them in these difficult times will probably have more of an impact on the relationship and define the relationship for the long term than anything you've done to date.
Absolutely, I completely agree with you, and I think that's what all of us have to keep reminding ourselves. Anyone who's running a business or have clients, that you need to be careful about that. Another question which has come up is, what if we have act of God resulting to termination of agreement and we don't have force majeure specifically mentioned in our contract?
I didn't understand that question. Typically, an act of God is a subset of the type of events that are covered by a force majeure clause. So if your contract says an act of God results in termination, that's pretty much like saying a force majeure event results in termination.
Okay. So even though it's not explicitly there,
it doesn't have to be called a force majeure. I mean.
Okay. That answers it. I think in the previous questions when I was talking to you about contract workers, this was specifically to do with customer care associates, typical BPO permanent employee. Is there a gray area in terms of where they stand in terms of are they the contract workers that we're talking about? I think they want more clarity on that.
As I said, it's a really tricky one. You've got to look at it on a case-by-case basis. The ones that are in the supervisory or administrative category or in the managerial category, you might have clarity on. But with regard to the others, I don't have a straightforward answer, and I wouldn't hazard one without looking at the specifics of that case.
Okay. So I think, the inputs to the person who asked the question is to really understand what level your employees are and then get advice from an employment and contract law expert and then make a decision. Always go back to your original employment agreement. If you have a 30-day notice period, then invoke that in terms of the 30-day notice period. I think that's really very, very important. Okay. I think we're at the end of our questions. We do have a winner in the social media challenge, Mayank Chawla. Congratulations. Thank you for tweeting. I think once the lockdown is lifted and we have deliveries happening, we will send that swag bag across to you. Ramanand, thank you so much.
Thank you, Latika.
Thank you for it being an interactive session.
And after that heavy session, I look forward to listening to some more of Hansal's music.
Yes. No, I think this is, personally, I've been getting a lot of questions from all the founders I work with in terms of what they should be doing. So this has helped me to help guide them when they ask me questions around how do we conserve cash, how do we trim, that's the whole mantra right now. And that it's a tough one. And I think for the first time, everyone is scurrying to read the contracts they have in detail, every single one of them. Before we have Hansal, perform, the best advice I would give, all founders, having been one, several times around, the biggest mistake I did was not engaging with a good legal team and a good accounting team up front. So please remember that if there is any one lesson that you should take away is to ensure that you are always working with a good legal and accounting firm. Thank you again, Ramanand. Hansal, over to you, my friend. Look forward to hearing your next number. Thank you, everyone.
Thank you so much. Thank you so much. It was quite informative for me as well. I was enjoying it. So, I hope you had a great time in this webinar and it was quite informative for you all. So just to end this session on a lighter note, this one is from my recent release, Dastan only. This is the second chapter of the Dastan in which the subject reaches to the mountain or the escape place of that particular and what he feels over there, like a homely feeling away from being home. So this is the song called Jahan. जहाँ है ये वहाँ से परे अपनों से दिल चले नए जहाँ है ये वहाँ से परे अपनों से दिल चले नए रूह में मेरे अभी सांस है गुनगुनाते अब मेरे अल्फाज है, खुशनुमा ये जिंदगी एहसास है, अजनबी ये वादियाँ कुछ खास है। यहाँ तो रिश्तों की किश्ती तो संग में गुजारे वो पल है, जो पल बिखरी सी मेरी ये दुनिया में खोए थे कल है। यहाँ तो भीनी सी मिट्टी की खुशबू में बसती है यादें, रातें ख्वाबों की यादों में यूं ही सहते है जागे। न गम है कोई न फरियाद है, न दिल क्यों बता तू अनजान है। न गम है कोई न फरियाद है, न दिल तू बता हो क्यों अनजान है। रूह में मेरे भी साज है, गुनगुनाते अब मेरे अल्फाज है, खुशनुमा ये जिंदगी एहसास है, अजनबी ये वादियाँ कुछ खास है। रूह में मेरे भी सांस है, गुनगुनाते अब मेरे अल्फाज है। दूर है कभी कभी सब पास है, अजनबी ये वादियाँ कुछ खास है, अजनबी ये वादियाँ कुछ खास है, अजनबी ये वादियाँ कुछ खास है। So that was Jahan from my recent release Dastan, and I hope you enjoyed it. You can check out my YouTube videos, just go there and check out my name Hansal Sitar. You'll find number of videos over there. Latika?
Hi, Anjali. Great. Thank you so much. Do you have one for us before we end, or
Sorry?
would you like to sing one more for us before we end?
I wouldn't mind if you want.
Yes, go ahead. We finish at 5:30, so we have time for one more song. Thank you.
Okay, then I'll do one more cover.
Yeah.
Yeah. Yeah, so this particular song is from the album Diwarist, and it is by the very famous independent artist of India, which is named by Ankur Tiwari and Pratik Puhat. The song is called Dil Be Parwa. थोड़ी थोड़ी है सबकी सुनी, थोड़ा कुछ तो सबने कहा, थोड़ा थोड़ा समझा भी मगर दिल ये माने ना, बस इसकी जिद है दिल बेफिक्र लापता। कैसी ये धुन है खुद कर भी कुछ ना मिला, इस दिल की आदत यही है, गिर कर संभलता नहीं है, जालिम समझता नहीं है ये कोई सुबह, ये दिल बेपरवाह, ये दिल बेपरवाह। कतरा कतरा हो गया दिल ये बिखरता गया दुनिया गुजरती रही टुकड़ों में चलती रही बस इसकी जिद है दिल पे फिकला पता कैसी ये धुन है खोकर भी कुछ ना मिला इस दिल की आदत यही है दिलकर संभलता नहीं है जालिम समझता नहीं है कि कोई सुबह ये दिल बेपरवाह
Great, thank you, Hansal. It was lovely. Thank you for
Thank
coming
you so much, Latika.
and elevating our mood before the legal webinar and kind of ending on a happy note. So
my pleasure, my pleasure.
To you, and I will definitely track you on YouTube now.
Thank you so much.
I'm a big music fan, and especially of musicians like yourself. So.
Oh, lovely. Thank you.
A big thank you to Sonia Choksi of Match My Talent in terms of helping us identify Hansal. I would have never known that he existed, so much appreciated. Thank you, Ramanand, for a fantastic session. And the team at Jen, Jiva, and Rahil and Kabir from my team for putting this all together.
Thanks, Latika. Thank you for having me on as well. And thanks, Hansal. That was really lovely.
Thank you.
And to your team as well. Thanks, Kabir and Jiva and Rahil.
Great. Thanks, everyone, and hope you all enjoyed this session. And if you have any questions, please let us know. Thank you. Bye. Great, thank you, Hansal. It was lovely. Thank you for coming and elevating our mood before the legal webinar.